Do you know if the court's running behind, Nicole, or are we on time today?
That is right.
So I'm getting some delay. Is it me or you guys?
I don't notice any delay on my end.
My internet might be. Now I cursed it by talking about it, right?
Yeah.
Okay. I mean, I guess that's all that matters, right? If people freeze on me for a couple of minutes, then I guess it doesn't matter too much. And you have us turn our cameras off when we're not arguing, right, Nicole? I remember that from.
Hey, Evan.
Good morning.
Morning. My office is feeling so messy now that I see it in this vantage point. I thought it would be a relatively distraction-free.
You go with a completely plain white wall.
I know. I was thinking of going up to a conference room, and I thought, no, I'll just stick in my office. And
Although I've had a couple of hearings in front of Judge Faust, and he makes fun of my wall, saying it looks like a prison cell.
yeah, now I wonder if I should blur mine. I think in the 10th Circuit has this option where they have some pre-selected backgrounds, and one of them is like this funny formal columns and like the front of a courthouse. But those tend to add some blur to your outline or something. I've at least moved my broken clock so it won't distract the judges. When why is his clock wrong? Why is that?
Good morning, Council. This is the case of Salt Lake City versus Inland Port Authority. We do appreciate your willingness to appear virtually on this matter. A couple of preliminaries before we jump into things. If we have a technical glitch, don't panic. They are to be expected, as we've all learned. And we'll take whatever time is necessary to ensure that you have a full opportunity to present your case. If we have a question, we'll raise our hand. That's to signal to each other, as well as to you, that we are in line to ask the next question. That doesn't mean you need to stop mid-answer to respond to the question, but when you can get to it, please do so. We have allocated specific time periods to each of you, and I know that the state and the board have divided their time. You should know, however, that it is our practice to continue asking questions as long as we have them. That may mean that you will exceed your time. Should that happen to you, you need not ask for permission to continue to respond. And any such extra time will not eat into rebuttal time, nor will it affect the time that has been allocated between the state and the inland port. Now, the inevitable result of that practice is that one of you will receive less time than the other. That's just a function of how many questions we have as to your particular case or issues. Okay, I think I've covered one other thing I should mention. It helps with bandwidth, as I'm sure you know, if you mute yourself when you're not speaking. And I think that's covered it all. So let's begin with council's appearances.
Samantha Slark on behalf of Salt Lake City.
Ms. Lark, welcome to have you with us.
Danford Purser on behalf of the state of Utah, the governor and the attorney general.
Good to have you here also, Mr. Purser.
Good morning, Evan Strasberg on behalf of the Utah Inland Port Authority.
Welcome, Mr. Strasberg. Okay, let's begin.
The city and the amicus parties ask the court to uphold 120 years of Utah jurisprudence and find the challenged provisions of the Act violate the RIPA clause and Utah's Uniform Operation of Laws provision. Utah's RIPA clause, like all RIPA clauses, was adopted to combat the problem of legislative interference with local affairs, often at the behest of special interests. The Act violates the letter and the spirit of Utah's RIPA clause in at least two ways. First, it delegates power to spend the city's municipal monies to an unelected and unaccountable board, and it directs the city what zoning it must adopt and what land uses it must permit for 1/5 of its geographic area. I will address each in turn. Justice Pierce.
Ms. Lark, maybe as you start that first one, if I could ask you a question. Is it the city's position, would a direct appropriation from the legislature be improper? Is it the diversion that causes the diversion of the tax funds that causes the violation of the RIPA clause? Or would it still be improper if the legislature did it with a direct appropriation?
And if I understand your question correctly, I think that we need to start with answering the question by looking at the character of the funds and who it is that actually has authority to raise these monies in the first place. And the monies that we're talking about in this case are municipal property tax monies and municipal sales and use tax monies. And the power to raise those monies starts with the Utah Constitution. It is Article 13, Section 5. And that constitutional provision says that municipalities, and only municipalities, can raise monies for their own municipal purposes. And it limits the state's role in that money raising to simply saying what type of tax it can raise. And here, Justice Pierce?
No, please finish. Sorry.
And here, the state says that municipalities may raise municipal funds for their own municipal purposes through property tax and sales and use tax. The monies at issue here by adopting an ordinance to levy those taxes. The monies at issue here are property tax monies raised by the city, and only the city is allowed by the Constitution to raise those, and sales and use tax monies raised in that same way. Therefore, what has occurred is money that only exists because the city raised them is being taken from the city and given to an entirely different entity to spend. So therefore, the power has been delegated to the authority to spend those municipally raised funds. Does that answer the question for you, Justice Pierce?
I think so. If I could just clarify a little bit. So the city's position is if this were direct appropriation from the general fund, at least this portion of it would not be a Ripper Clause violation. There may still be other issues, but it's the diverting the sales tax differential that causes the problem.
And I want to make sure I understand the question correctly. I don't think any taking of municipally raised money would be appropriate because a municipality is the only entity that can raise that money. So whether it's taking it from the general fund, which 1/3 of the general fund is made up of municipal property tax monies, or whether it's taking it once it's raised before it hits the general fund. Any way round, the character of these funds are municipal because only a municipality can raise these funds. The state can't. They wouldn't exist but for the city making that levy. Justice Lee.
I have what I think is a follow-up question, but I don't want to interrupt Justice Pierce's line of questions.
No, go ahead, please.
It seems to me that your strongest argument that there was a delegation of power is the idea that the statute delegated to the authority the power to decide how to spend this money. But then beneath that is the question of whose money it is, right? And there are arguments in the briefs about how to think through that. I wanted to throw one thing out there for your consideration, and you can help me if I'm missing something on this. I'm looking at Article 11, Section 5 of the Utah Constitution that says, among other things, that the power conferred on cities includes the power to levy, assess, and collect taxes and borrow money within the limits prescribed by general law. And I'm wondering, you don't have a special laws challenge to this statute. And so it seems like one way to think about this is that the legislature has imposed limits on your ability to levy, assess, and collect taxes. And that if it's not a violation of the within the limits prescribed by general law provision of Article 11, Section 5, then it's state monies for purposes of the Ripper Clause analysis.
So I think I would disagree. Well, to start, yes, the analysis is correct. As you set forth in the brief, the first argument is that the delegation of power to spend these monies, and then we're looking at the character of the monies. With respect to whether they are state monies, I think that that is incorrect. You have to look at the source of who has the ability to raise those monies in the first place. And so the state has no ability to raise the municipal municipal monies that are at issue in this case.
But this is where I'm wondering if Article 11, Section 5 doesn't help us because it does put a limit on how the legislature can limit the power of cities to levy, assess, and collect taxes, and it's within limits prescribed by general law. So if the statute at issue in this case is general law, and I don't think you have a special laws claim, then it seems to me that that is a constitutionally prescribed limit by the state on the city's power to levy, assess, and collect taxes, which would render it state money for purposes of this analysis.
Well, we do have an equal protection claim in this case, which is very similar to a special laws claim. And I think that your argument would be more appropriate were the law of general application. If, for example, the statute was passed and all municipalities statewide suddenly had their taxing levy ability reduced by exactly the same as Salt Lake City did, then yes, that provision would be of assistance in finding that it was constitutional. But that's not what happened in this case, and it's really what the city's equal protection argument is that the tax monies are being on the ability to tax. It's just being limited for Salt Lake City and parts of two other jurisdictions.
Does that mean, so does your Ripper Clause analysis with respect to this question depend on the viability of your uniform operation of laws analysis? I don't see how it doesn't, because it seems to me that if the legislature has the power under Article 11, Section 5 to limit the power of cities to levy, assess, and collect taxes, and the question is just, seems to me that it's all controlled by whether the legislature has exceeded its power in limiting the city's authority to levy, assess, and collect taxes.
I mean, I think that there's definitely a connection, but I do think the two analyses exist independently of each other. And your questions really go to what are the character of the funds and how do we determine the character of the funds? So I don't think that you can pass a law that just changes the character of funds for one municipality and one little section of their funds, because I suppose that becomes a special law or an equal protection violation. So I guess they are the two arguments that coexist in that extent, but they are definitely two different analyses, because the question that's relevant for a Ripper Clause analysis is what are the character of the funds? Are these municipal monies? And but for the existence of this statute, which attempts to change the character of these funds just for Salt Lake City, they are municipal funds that every other municipality gets to raise and gets to spend.
So I want to make sure I'm understanding this point also. After the act, so before the act, whatever property taxes were levied and collected in the jurisdictional land, in what is now the jurisdictional land, that was Salt Lake City money. Paid by Salt Lake City taxpayers, it is Salt Lake City money raised by Salt Lake City. Going forward, with the act designating this money as the tax differential that is going to fund the authority, is the city is still levying this property tax, but the state is saying, the act is saying, even though the city is levying this property tax, we are taking off 75% of the increase after 2018 and going forward, and we're giving that to the authority. So is it still a city tax? It's just that the state is laying claim to, the state is taking a portion of the same tax that was collected before and is still being collected, taking a portion of the increase, giving it to the authority and saying the authority now gets to decide how to spend that money. But it's still a tax levied by the city.
That's absolutely correct. It's tax levied by the city given a fancy name so it doesn't sound like it's municipal money anymore, but that's exactly it. And I think there's another important point which is interesting to bring up here. Not only is the power delegated to the authority to spend this municipal money, the statute also gives the authority power to extend that initial 25 years of spending that money at the authority's discretion for up to another 15 years. So that power is also being delegated to the authority.
One thing I'm wondering if you could comment on, and I'll ask the state to comment on this too, but it seems like their answer to your argument is, well, it's not municipal money anymore because we gave it to the authority. And we have the power to do that, and so it's no longer municipal money. Do you understand that differently? Is there
I
something
think
that I'm missing in that argument?
I think that is the argument that the state is making, but I think it's a very difficult argument to understand. The RIPA clause precludes and protects against interference and supervision of municipal monies. So municipal monies is a thing that exists. Therefore, if you can simply change the name of something and no longer call it municipal monies, then the RIPA clause has been stripped of any meaning. And we know that that is an interpretation that we cannot reach. So if you can just change the character of the funds by passing a statute and calling one municipality's funds something different, then you have completely eviscerated the protection against interference and supervision of municipal monies that is protected by the RIPA clause. So that cannot be the way that you look at the character of the fund. You have to look at the character of the fund as who gets to raise them. Who's the only person that's allowed to do that here? The Utah Constitution says the only person that can raise these property and land and sales and use tax monies that are being delegated is the municipality. I see I'm running rather short of my 15 minutes here, and I think a really important point that I would like to touch on before I close is that we do have two very distinct RIPA clause arguments here. The first is the delegation of power to the authority to spend these municipal monies, and the second one is that this direction that the city must adopt certain zoning and land use for 1/5 of its geographic area, which notably is 1/3 of its developable area. And the first part of this analysis is that provisions directing a municipality in the performance of its municipal functions are subject to the RIPA clause. And this is not a new or a radical position by any means. I see that I am out of time.
I'd like you to continue in answering it, and I have some questions along these lines. Maybe in your answer, I just want to make sure I understand with the new amendments to the law, to the act, there's now not the appeal board, right? So there's not that veto that you were concerned about before the amendment. But if you could just explain in practice what land use decisions, what development decisions will the authority be doing on the jurisdictional land that you're still concerned about? So I know that you're concerned that you have to, as a matter of zoning, agree that this can be used for port purposes. But beyond that zoning question, what control over this land does the authority have in its development that usually the city would be performing?
Right. And I'm going to answer this in two parts. And I'll answer the second part first. The first part, as you correctly observed, and will have noticed in our briefing, is that we very much so direct mandates to the city as to what zoning and land use it must adopt have to fall within the RIPA clause. To get to your second point, what kind of land uses, developments, infrastructure decisions are going to be made by the authority? And this is where a lot of the delegation of power with respect to the money and also dovetails with how that develops and jurisdiction in that dovetails with how a municipality develops. Municipalities use those monies to plan how their roads are going to be constructed, how their utilities are going to be supplied, and how basically to run their city. They work with private development, they negotiate with private development for the construction of those. And they do that with very long-term plans in mind, because municipalities have to plan, 25, 50, 100 years in advance. And so roads, utility lines, capacity for all of those things are very carefully planned and in line with everything else in the rest of the city. So it all kind of dovetails together. If you give the property tax monies, which are used as incentives to fund these kind of things, and you give them to the authority, and then the authority has power to negotiate with private developers to make agreements with respect to all of these municipal infrastructures, then all of a sudden you've delegated all of this kind of planning authority to an unelected independent board, which drives how the municipal development evolves out there. And then the city at the end of the day ends up holding the bill with respect to maintenance and probably essentially ownership of all of this infrastructure that it didn't plan for.
What is your argument that the zoning requirement is a delegation of power and not just a direct mandate from the state? Can you explain that argument a little more?
It is a direct mandate from the state, but the argument is that direct mandates get analyzed under the RIPA clause as well. And this is the reason why. It is not a radical or a new position that the city is making here. In 1901, this court, and this would have been right around the time when the Constitution was adopted and the RIPA clause was adopted, this court in state ex rel right found that several provisions of the Utah Constitution imply a right of local self-government. And I think a quote from this court's case is really apt here. And it said, the right of the legislator is to provide for and put in action, not to run and operate the machinery of local government to the disenfranchisement of the people. And this conclusion was reached by, as this court always does, looking at the terms of the provision at issue, so here the RIPA clause, and reading those provisions in the context of the conditions and necessities under which the provisions originated, and in view of the purposes sought to be attained and secured. And here we know that those purposes were to prevent legislative interference with municipal functions at the behest of special interest. And here we have legislative interference with zoning and land use at the behest of basically a private development. We can't forget that the inland port is essentially what it is. It's a private development that we constructed, owned, and run by a private developer. Justice.
It seems like your argument would be different if the state just made such a mandate and said, in this part of the city, you have to allow for this type of zoning. But it sounds like what you're saying is it's combination, that you can't divorce the act first saying you must permit an inland port use, and then in the area where they have required that, giving the authority to the inland port to make all of those infrastructure and development decisions within that authority. If it were just a land use requirement by itself, would you be making the same argument?
I think we're making both arguments. I don't think that the state has the ability to direct zoning within a municipality. And also we have the additional problem of all of these other planning functions which will go along with the allocation of the delegation of the powers and the delegation of the money. And one other thing I would like to draw the court's attention to, which was in the city's briefing, is that again, this isn't new. In 1962, in Bachman, this court analyzed without question a statute mandating a municipality to take a certain action. In that case, it was to put a proposition on an election ballot that, if it passed, would require the city to give up all kinds of municipal powers to a new body. And the court there analyzed that mandate, that instruction, directly to the city to do something, and found that it was a violation of the Ripper Clause. So the idea that the Ripper Clause applies to direct mandates as well as delegations of powers is not new. And this court has already ruled in line with this, recognizing implied rights to local government, and also just very directly in Bachman finding a Ripper Clause violation from a direct mandate.
I have one very quick last question back on our first topic. When you argue that the state has no ability to raise this money, that only the municipality can raise this property tax money, so are you saying that if hypothetically the city said, fine, we're not going to tax this property, we get rid of the property tax, or we freeze it at 2018 rates, could the state impose it?
So I think that really gets to the heart of the matter. Say the city said, we're not going to raise these tax monies, we're not going to put our levy in this year. There would be no money. There would be no money in existence, and there'd be no money to give to the authority to spend. Could the state raise other taxes? Of course it can. Like, the state raises taxes in different ways all the time. So yes, the state can go off, and it could, if it really is claiming that this is for a statewide purpose, you can impose a statewide tax and tax everybody in the state for the alleged statewide purpose. But I think your question really gets to the heart of it. If the city decided not to raise property, to exercise its levy and raise any property taxes, there'd be no money for the authority to have. And if the court doesn't have any questions for the moment, then
Thank you, Ms. Clark. Mr. Strasburg.
I believe Mr. Purser was going to go first.
Yes, I'm mistaken. I apologize for that.
Thank you.
Mr. Purser.
Oh, that's fine. The city has not met its heavy burden to show that the challenge provisions of the Act clearly violate the Ripper Clause or the Uniform Operation of Laws provision. I'd like to focus, as the court did with the city's council, on the delegation issue. And first, talk about the zoning and land use provisions. Of course, all of this starts with the text of the Ripper Clause, which specifically says it prohibits the legislature from delegation. And this court, too, in the city of West Jordan and other cases, has emphasized that the Ripper Clause is only implicated through a delegation. Now, the zoning and land use.
Mr. Purser, but Ms. Slark makes a fairly decent point that a number of our cases have in fact found directives or mandates to violate the Ripper Clause, or not, and Wright is the prime example. Right?
Yeah, I'm glad you asked that. The State Ex Rel Wright from 1901 is not a Ripper Clause case. It invokes an implied right to self-government. At best, it might be an Article 13, Section 5 case.
I gather, I mean, and looking at Wright, there is no discussion of this distinction. And I take your point, but it's not just Wright that she points to, and I think correctly points to that there have been, perhaps without any analysis, directives or mandates seem also to have been put in play.
I don't think so. I've not found that case. I've looked at the city's cases. Again, the State Ex Rel Wright just isn't a Ripper Clause case.
Fair.
And the Blackman case they rely on from the 60s. One that may be the strangest case I've ever read. The court starts off saying we don't have jurisdiction, this issue is moot, and then it carries on for several pages opining on several different claims. But to the extent it does, and it does address the Ripper Clause in dicta, but that court expressly says that delegation is a necessary element to a Ripper Clause claim. And to the extent it criticizes the law at issue, it says it criticizes the law because it attempted to delegate to a special commission power to perform a municipal function. There is a mandate there to have an election, but that's not the provision that the court was talking about in the Ripper Clause section. So Blackman offers no authority.
Mr. Purser, just because you have a direct mandate as part of the act, does that sort of immunize the state from the Ripper Clause? So I guess what I'm asking is, if in substance, what the act does, and let's just talk about the tax money for a second. If what the act does is it says, first, Salt Lake City, we are taking this part of your future tax revenue that is from taxes that you're levying. We are going to take a portion of the growth of that going forward, and we're giving that to the authority, and now the authority gets to decide how to spend it. Saying we're taking your money, we're giving it to someone else to decide how to spend seems like a delegation of spending authority. Now, it's accomplished through a direct mandate and a grant of power to the authority, but does that make it not a delegation? Can you explain your analysis of that, your reasoning about how that sort of avoids being a delegation under the Ripper Clause?
Yeah. First, we're bound by the text of the Constitution, and the Ripper Clause expressly requires a delegation. To read delegation as also including a mandate just reads that term out of the Constitution. Two, and this is a more general answer, this court in West Jordan, one of the claims that the city there made was that they just simply said, hey, the direct mandate here to force us to remain in the retirement system violates the Ripper Clause. This court called that claim meritless, and it said statutory provisions. Part of this is me paraphrasing, and part of this is quoting, but it's on page 533 of that decision. But the court said statutory provisions that do not delegate, quote, any powers to anyone, quote, but, quote, simply regulate how municipalities must perform a function, unquote, do not implicate the Ripper Clause. This issue is settled. Now, to get specifically,
I understand, yes, the Ripper Clause uses the word delegate, but I guess I'm asking you, how in substance is it not a delegation to say we're taking money that would have been part of your budget that you have raised, we are giving it to the authority, and we're giving them the power to decide how it's going to be spent. In substance, how is that not a delegation? It seems there's a little circularity in your argument, because you're saying, well, they're not delegating power because the money's already been taken from the city and now it's the authority's money. So it's not city money anymore. There's a little circularity there because it was given to the authority under the act. It's two different steps. Money is taken from the city, given to the authority. They get to decide how to spend it. How, as a matter of substance, is that not a delegation of the power to spend the city's money?
Well, first, as I read the city's complaint and their constitutional challenges, they've challenged the mandates. They haven't challenged other provisions of the act. But let's assume that these other provisions that do delegate some spending authority to the authority are part of their constitutional claim. Their theory is that under Article 13, Section 5, taxes that they levy are automatically and forever and permanently theirs, no matter what else may happen to them, no matter whether they collect them, no matter whether they ever pass through city hands, that by virtue of them levying the tax, it's their money. They have no authority for that proposition. Article 13, Section 5 doesn't say that. Moreover, as Justice Lee pointed out, Article 11, Section 5, Clause 7, contradicts their argument, and it expressly allows, it limits the city's power to levy, assess, and collect taxes, quote, within limits prescribed by general law.
Can I follow up on that?
Can I ask just one quick question?
Of course.
I think we're on the same track. In this argument, do you disagree with what Ms. Slark said, that if the city decided we're not levying this tax anymore, we just won't have a property tax in the jurisdictional land, could the state go in and levy that tax?
Yeah, I believe the state has the authority to levy a property tax, but I'm not sure it matters here. As part of the property tax at issue, it's not just city, or it's not just the city that is levied a tax here. As all of us know from our own property tax notices, there's county, there's water district, there's school district, there's sewage, there's about a dozen different things on our property tax notices. And as I understand the act, it reallocates all of those property taxes. So if the city decides, hey, we're not going to do a property tax anymore, the city can do that.
But so are you saying there would be other entities there's still the water and the utility, or are you saying the state could go in and levy that property tax itself?
Well, in addition, here is an amendment that's not an issue in this case. The act now creates an infrastructure development district, and that district, under some certain guidelines, would have the power to levy a tax. But as a special district, it would need to get the permission of the property tax owners.
So the provision that you cited about the state can limit the city's ability to levy a tax, that's not really what's happening though, right? You're not limiting their ability. You're just saying the taxes that you've levied and that you collect, we're taking some of it and giving it to the authority going forward.
No, that's not what it does. The city doesn't collect these taxes. These tax mandates aren't even directed to the city per se. The property taxes are collected by the county, and the county distributes the appropriate amount to the authority.
But these would have gone to the city if not for the act. The property taxes would have been given to the city, the ones that were collected. So correct me if I'm wrong, but I thought the whole point of the tax differential was that this property tax that right now goes to the city, it's still going to be collected, but instead of going to the city like it would have, this portion of the increase is now going to the authority instead.
Right, but under the old adage, possession is 9/10 of the law. The city never collects or possesses this money. They just sort of have this bald claim that it's ours, when in fact it never goes to them or through their hands into their coffers or part of their fisc.
Let me ask a hypothetical. Let's say that the state legislature, instead of doing what it did here, passes a law that says, I don't know, most of the Port Authority is located within Salt Lake City. Therefore, even though every other city gets to collect its, receive the property taxes that it levies. Salt Lake City's property, 25% of Salt Lake City's property taxes shall be paid to the state instead of to the city. Can the legislature do that?
That might border on a special law, and there might be other prescriptions against that. But that's not what's happening here. If I could, well, I don't want to.
Special law would be the limiting principle, and I guess possibly uniform operation of laws as well. But that's really the only limiting principle you see on the legislature's ability to divert or redirect what would otherwise be city property taxes.
Well, I'll confess I have not reviewed the entire Constitution to answer
That's fair.
this
I'm
question.
asking you an unfair question.
But I mean, as far as what they're alleging here, and it's important to remember, they have not brought an Article 13, Section 5 claim. The only basis for them to claim that these tax mandates are unconstitutional is the Ripper Clause. So they have to abide by the terms of the Ripper Clause. And if I could add, you might be on mute, Justice Simonis.
Thank you, Mr. Purser. I was just saying, please finish. I was just signaling that when you're done, I wouldn't mind asking you a couple of questions.
So if I take up the rest of my time, you won't be able to ask me. No.
I don't, I think you know us better than that by this point, Mr. Purser. I think you all know us better than that.
I do. If I can make a couple of quick points about some cases that I think address the city's Article 13, Section 5 argument. This court has already rejected similar arguments in the Murray City redevelopment case, which brought both Ripper Clause and Article 13's Section 5 claims. That case involved a property tax differential reallocation. And in part, the county had argued that, you're taking our taxes and you're sending them to Murray City and you're causing us problems. And this court said, quote, it is, quote, simply incorrect when it says, the plaintiff, that it will be deprived of its taxes, which will only benefit Murray City. And the court went on to say, as a matter of fact and as a matter of law, plaintiff Salt Lake County is not being deprived of its power to assess and collect taxes for all purposes of such corporation. The Mountain States Telephone and Telegraph case has similar language. In that case, there was a direct mandate to the counties that the counties had to provide some excess revenue to be some excess tax revenue to be redistributed to other counties. And this court rejected an Article 13, Section 5 argument. And the court said, the legislature has not interfered with the right of the county under local self-government to assess and levy taxes for its own purposes. So the city's argument, I think, has more or less been rejected. But overall, I think the point is the city cannot come in and just rely on Article 13, Section 5 and say that shows a clear violation of the Ripper Clause. It doesn't. They just haven't connected to the extent there's other dots out there to connect. Their argument does not connect them, and they haven't carried their very heavy burden here.
Help me understand the mechanics of the tax process, and I confess to not really having this very well in mind. But the sales, use, and property taxes at issue here are levied by the city, even if they're collected by the county, right?
They are, yes. So as part of, I think in Salt Lake County, I think there's like a 7.75% sales and use
Right,
tax.
but it is the decision of the city council to levy a certain percentage of these taxes. And then the collecting arm is indeed the county. But if those taxes were levied, they would ultimately flow to the city's general fund.
It's one point is I think the sales and use tax are collected by the tax commission.
Okay.
And then this statute directs essentially the tax commission to distribute, you know, a certain percentage of the sales and use tax. But then to answer your question,
I just want to get the mechanics down. I mean, not the argument. I just understand
right.
that there's a levy that comes from the city or cities, from the municipal agency, as a matter of, you know, kind of good governance and making it efficient. We might have the tax commission or the county collecting the various taxes, but then ultimately, absent a directive, right, those funds in this instance would find themselves in the city's coffers at some point.
yes.
And I take your point that there is a directive that then redirects, if you would, the money to the IPA, right? Right. And now to Justice Peterson's point, all right, you have this directive, but once that's happened, there's also then a part of the enactment that allows the IPA to take these redirected funds and to determine how they're going to delegate to them how they are going to be spent within certain limits. But the spending of those money then is no longer, how those funds are spent is no longer done by people that are accountable to the electorate in the area in which the taxes were raised.
Yes, but our point is that the city hasn't shown with its sort of bald assertion under Article 13, Section 5, that those funds are municipal.
Not lost on me. I get it. I'm just saying this is practically, this is how it works. And if we were to reject that argument, I'm not sure how far the directive or mandate versus delegation gets you. I mean, there is a fair part of this that feels like there is now an entity that is not directly accountable to the electorate, that is spending tax money that is only raised from the electorate in a particular area. And I will tell you, that is perhaps the most troubling aspect of all of this to me. And it gets me to the real point I want to make or question you about is the uniform operation of the laws clause challenge here. Let's just assume for me that there is a challenge, and we're down to application of the rational basis test of the Judd v. Dresga standard. Or if you're with me, what is the rational basis for saying we're going to redirect these funds for this project that the state is thumping its chest far and wide? This is all about the state. That's why we need to be involved. City can't do this. This is for the benefit of the entire state. But citizens of every place other than Salt Lake City, you won't be responsible for any of this. That's maybe the crux for me of the uniform operations challenge. What's the rational basis for that decision?
Well, to be functional, the Port Authority, it needs funds.
But it can raise funds from the citizens. I mean, if we credit the state's argument that this is a statewide benefit, then why shouldn't the statewide pay for it?
Well, but that's not a rational basis question. That gets to intermediate or higher scrutiny. That's a narrow tailoring question.
So I'm asking you to tell me then, give me the rational basis for the decision to impose a levy, effectively levy a tax only on the residents of the special jurisdictional area for a project that is conceded to have statewide benefit.
it's not only a tax on the city. It's a sale. There are multiple entities that are part of the sales tax. If you look at the taxing provisions as part of the 7.75% sales tax, there's city, there's county, there's there's other taxes. So
But it's only the portion levied by the city that is subject to the increase.
No, I believe it's the city and the county. In part, this is section 602 6 of the act. And what really happens here is
I don't know that making it the county helps you, Mr. Purser. I mean, even if it's the city and the county. I mean, really, the ultimate question is the legislature has made a decision to fund a statewide project with the funds from a distinct geographic area. What is the rational basis for that decision?
because the area jurisdictional land, the strategic location of where this port authority is developed, is going to benefit immensely from this development. Both the property taxes will go up, presumably the development, if it goes as planned and is
Can I summarize what you're saying this way? Is yes, that's correct, but it passes rational basis scrutiny because the legislature has or could determine that the primary beneficiary, even if it's a statewide benefit, the primary beneficiary is in the immediate area, and therefore we're going to impose the primary burden on that area.
I don't know that it's the primary beneficiary, but it's definitely, well, oh, sorry.
No, I was pitching you a grapefruit there. I mean, I don't know if that passes or doesn't pass it, but isn't that effectively it? Is that there's a legitimate basis here? Look, it's the legislature could rationally decide that the primary beneficiary of this project, even if it has statewide benefit, is this geographic area.
Yes, it could, but in addition to the tax mandate redirects 50% of the sales tax to the authority, but then the authority in section 602 6 is told to send all of it divides it between a point of sale portion and a retail sales portion, and essentially most of that money is then sent back to the city or to the county. And point of fact, the authority keeps very little of it.
Thank you. I'm done for my colleagues. Thank you.
I have, I think, a related question, if I could jump in here. There's assertions in the city's brief about the hundreds of millions of dollars of property taxes that are going to be lost. I wondered if anyone had tried to do any sort of a net analysis of tax revenue gained as a result of the port authority versus tax revenue diverted away from the city, if that makes sense.
Yeah, I looked for that and I couldn't find it. That doesn't mean it doesn't exist. It's not part of the record as far as I could find, and I couldn't find a sort of publicly legitimate source that I thought the court might be able to take judicial notice of.
And I wonder whether, even if we don't have the hard numbers, whether that might be part of the rational basis as well. That the city is going to benefit from this in addition to having to pay some of the freight or have some of its taxes diverted. It's also going to benefit, and if that might not be part of the rational basis.
I think it is. I mean, if the port goes off as planned and as the feasibility study projected that it could, if the state really got behind it, I think, all boats are going to rise from this.
One uniform operation question I have that sort of dovetails with Justice Himona's question is, so right now the tax money that's being diverted is money that is being raised by Salt Lake City, and that's not optional. The city can't decide not to do it. This is a mandate in the statute. But in terms of development of satellite inland ports throughout the state, those local jurisdictions and municipalities can choose. The state won't do it unless they consent. And some of the analysis in the briefing, it kind of sounds in, look, we need this to be coordinated statewide. The state needs to do it because for this to be successful, we predict that there will be satellite ports throughout the state, and we need not just a municipality governing it, we need the state level perspective in coordinating this. And this area of the jurisdictional land is so important that we have to mandate participation. Why is that not also true for satellite locations? If the authority decided, okay, we have some very strategic locations throughout the state, and if we really want this to grow, we need St. George in this because they've got I-15, they have an airport, they're crucial for connection to, I'm not sure what, this is just a hypothetical. But if the authority thinks, okay, sure, we want consent, but boy, we see a few other areas that if these satellite locations don't participate, it's really going to limit the scale of what we can do with the inland port. But they get to consent, they get to choose. The authority isn't given the power to say, no, sorry, St. George, if you don't want to participate on these terms, we're forcing you. That's not in there right now. So why, and it may be very strategic, why is it a requirement for the current original jurisdictional land, but for the development in satellite areas, that same rationale is not being applied, that we need the perspective of the state coordinating all of this to really make sure that it reaches its potential? Why is that same analysis not being applied consistently across the state for the development of the inland port?
Well, a few answers there. One is that this port is developing in stages is no reason to say that it lacks uniform operation of laws. Two, the legislature determined because of the strategic location of this northwest quadrant that on this hub and spoke model, we've got to develop, we've got to get this hub going first before it makes sense to then say, well, where else does it make sense to have a satellite port? Once those satellite ports come on, they too are subject to the same provisions of the act, of the zoning, and all those provisions apply to them. But the mere fact that the legislature didn't also go ahead and determine what other port areas might be involved in this, I think doesn't show that there's the equal protection problem.
That's not really the hypothetical, though. What I was saying is what the act doesn't do is it doesn't give the authority the power to say, going forward, if the authority were to determine that a certain area of the state is strategically crucial, the authority can require participation in the same way that it is in Salt Lake City. It doesn't give it that authority now, although, correct me if I'm wrong, if we say that this does not violate the Ripper Clause, the state could do that. The state could go into any municipality and say, we are taking some of your land, we're requiring you to zone it for the inland port, we're taking some of your tax money, and we are going to control that.
Yeah, the state, under the same authority that it has to establish the current inland port location, could do that. The Port Authority has no authority to do that. And just to clarify that the state isn't taking any land there. There's been no condemnation or eminent domain.
I
The
understand requiring zoning, requiring that zoning allows for an inland port.
Yeah, the equal protection or the uniform operation of laws problem that the city raises, that some cities have to participate and others don't. It's a function of the area jurisdictional lands around the strategic location that has an airport by it, has a new prison where the state is pouring in hundreds of millions of dollars of interest of infrastructure. It's located at the crossroads of two major interstates and has transportation facilities. This is really a unique strategic location that has long been identified as a prime spot for an inland port, and it's the city's proximity to this that creates the classification. But there is no disparate treatment. All cities that are part of the area jurisdictional land are treated the same, and cities that are not part of that land are treated the same.
Justice Peterson, do you have other questions? Or I have two questions. One follows on what Justice Peterson was asking. Is the state aware if this funding mechanism has been employed in other instances? Is there any other example in the Utah Code of a differential being diverted to a separate organization away from the municipality?
Well, yeah, as I just talked about in the Murray City redevelopment case that involved a property tax differential reallocation issue. There might be that the port might be able to speak to this more. There's a MIDA Act, and this act was based off of that might have similar taxing, but I'm not sure about that.
Okay, thank you. The other question I have, I'm curious of the state's response. It's sort of buried in the city's brief around about footnote 112. But the city takes the position that because the authority can determine the type, timing, and quality of municipal improvements, that therefore it has been delegated the power to make a municipal improvement. And does the state have a response to that?
I'm honestly not sure what they're talking about. If the authority wants to build a building, I mean, it has to buy some land first. If it wanted to build something, it would have to go through the city processes to get approvals, permits. The authority just doesn't have power to do whatever it wants in the jurisdictional land. The city has its own zoning overlay over the area jurisdictional land. The authority and all the property owners have to abide by that. City regulations. I'm sorry.
No, please, Mr. Purser.
City regulations and ordinances still apply in the area jurisdictional lands. That these limited provisions simply say, hey, affected cities, you can't prohibit an inland port use, and you also can't prohibit some natural resources, transportation and storage. It's a pretty limited mandate.
So in the state's view, does the authority have the ability to decide where roads will go, where sidewalks will be built, or does that power all remain with the city?
It remains with the city. I mean, the authority is primarily a coordinator, a planner, a developer, getting stakeholders to work together. It's not. It doesn't have sort of legislative raw power to impose its will. from the city on city lands and on private property. They're all still subject to city city ordinances. My time is up, and if there's no further questions, the state will submit.
Thank you, Mr. Purser. Mr. Strasburg.
Thank you. May it please the court. I can see from sort of the direction of the questioning that there are certain areas that seem to be of concern to the court. And so rather than sort of go through some of what I might have addressed, I think I'd like to address at least a couple of points. Going to the issue of the redirection of the property tax differential, a couple of points I think are important to make. Historically, there has been no differential in the municipal area, or I'm sorry, in the jurisdictional area. And that's because it just simply hasn't been developed. And so at the end of the day, what you have is a project that clearly, in terms of the rational basis, standpoint, is going to benefit the jurisdictional land. And the statute specifically says that the tax increment comes from all areas within the jurisdictional area. It's not just Salt Lake City, it's if you're in the jurisdictional area. And that is because that is the area that is going to benefit from the investment that is being made most directly. Now, certainly, it is the position of the port that this project will benefit the state as a whole. And certainly, if the court is interested in hearing argument on that, I'm happy to address it. But at the end of the day, the city also now keeps 25% of the increment. And while I'm not aware of an analysis with respect to what does it look like with or without the Inland Port Authority proceeding, certainly there is going to be a lot of development. There's going to be a lot of opportunity that is realized as a result of what the authority is doing and how it's working to maximize opportunities that otherwise wouldn't be there.
Can you explain what you mean by there was no tax differential? I mean, isn't the differential just the growth after 2018? So are you saying there was no property tax collected from this area before because it was relatively undeveloped or it was very low?
There wasn't a lot of growth in this area. It's simply been undeveloped or underdeveloped up until now. But turning to sort of the fundamental question about whose money this is, this court in Tribe said the law is well settled that in exercising the powers of the state, the legislature may require the revenue of a municipality raised by taxation to be applied to uses other than that for which the taxes were levied. That's been the law since Tribe, and I don't think the city has raised any particular direct attack on that case law. Now, that also flows from Salt Lake County versus Salt Lake City, but I think in 1913, where although it wasn't the redirection of tax, this court had no problem saying that the city could be required to pay for something that the city didn't necessarily want. And so whether it's redirection of tax funds or requiring them to pay, it's long been the law of this court that that is something that the state can do.
I wonder if you could address it this way. So yes, the state could, earmark city tax dollars or take city tax dollars for a purpose, even if the city didn't want them to do it. But the city doesn't have the authority, or the state doesn't have the authority to do that in a way that violates the Ripper Clause. So by saying, well, the state has the power to do this, that gets you half of the way there. But if they take the tax money and give it to the authority, and if we think the authority is a special commission, if they take that money, redirect it to the authority, and give the authority the power to spend it, have they done this in a way that violates the Ripper Clause?
I don't believe so. And the reason why is because if the Ripper Clause works that way, then the exception swallows the rule stated in Tribe. Because what Tribe says is you can take this municipal money and redirect it for other purposes. And if we're reading the Ripper Clause to say, no, actually, you can't take municipal money and redirect it for another purpose, then then we've written Tribe out of existence. That statement of the rule simply can't fly. And
reading the way you are seems to swallow up the Ripper Clause, because if all the state has to do is just give a mandate that the money is first given to the authority. And let's assume the authority is a special commission. I know that's a separate debate, but let's assume they are. If all the state has to do to allow the authority to have control over how tax money is spent, Salt Lake City tax money is spent, if all they have to do first is say, well, we'll just mandate that the money be given to the authority, and now it's not the cities anymore. So that's a direct mandate. We have the authority to do that. And now we give it to a special commission who gets to control how it is spent. That's different than if the state said, okay, Salt Lake City, we're requiring you put money into project A, or you have to spend it this way. Now you still get to govern that. You're still in charge of running that. Well, that would not violate the Ripper Clause. But how is the way that it's being done here not a delegation of spending authority to the special commission, the authority here? How is that substantively different? Even though, yeah, you have the authority to do it in the first instance, but maybe not the authority to give it to a special commission and give them control over spending that money.
Well, I would answer two ways. Number one, obviously, we take serious issue with the question with whether or not we are a special commission. But in terms of answering the direct question, I think it still comes down to this. Maybe it's semantic, but I think it's meaningful. This distinction between what is municipal money, when is it municipal money? Because and if we come back to again Salt Lake County versus Salt Lake City. That was a situation where the city was being forced to spend money on something that it was not supervising. This was creation of homes that would house what was characterized then as juvenile delinquents. The city didn't want to spend the money. The city wasn't going to be in charge of the program, but this court still had no problem saying that they could be forced to spend that. But I think if we come back to the Constitution, and Article 11, Section 5, which has been discussed today, which again is not there's not a claim of violation of that, but it's interesting that the powers that are granted to the municipalities are to levy, collect, assess, and borrow. Now, one word that's not there is spend. That there are certain powers that are clearly granted, again subject to, as Justice Lee pointed out very early on. The legislature can still revise that. But even amongst those powers that are granted constitutionally, it doesn't say they have the power to spend. And I think that if you look at the literal wording of the statute and you look at the case law from Salt Lake County versus Salt Lake City into tribe, I think it all blends together and tells you, look, at the end of the day, this issue is resolved by saying it's simply not their money. And if it's not their money, it's not under the Ripper Clause redirection or interference with municipal funds.
I don't completely understand this argument that it's not the municipality's money. So you're agreeing that this is money, tax money that they have levied and raised, and that but for the act, they would receive and they would spend in their budget. And so the act says, we know this is going to be developed. Tax money, the property tax value is going to increase dramatically, and that increase, you don't get to keep it. It's going to the authority. How is that not municipal money? I'm not understanding the substance of your argument. Has to be more than, well, it's not their money anymore because we took it from them. Because that's the whole question before us is, can you do that? What's the argument that this is not municipal money?
Well, I think the argument is the state retains the power to redirect funds before they arrive at the city. That is what tribe. That's what tribe says. And so if we're gonna give that any meaning, then and again, I'm trying to sort of synthesize all of this at the same time the court is, but to make sense of tribe, to make sense of Salt Lake County versus Salt Lake City, to make sense of the Constitution and what has happened for 100 years, where I don't think there's been a case where this court has held that the state is not empowered to redirect funds raised by taxation for some other purpose. To say it's their money, I don't know. I can't necessarily say at what point it becomes their money, but it's not simply by levying, collecting, assessing the tax. If it were, then I don't know how tribe. I don't know how
So-
that could have been reached.
Starting with that premise from tribe that the state can do that, does the Ripper Clause, the language of the Ripper Clause, though, say the state can't do that in a way which delegates power to a special commission to interfere with the municipality's money? So they can divert money and they can divert it to something that maybe the city doesn't want to do, but can they divert it to the authority to spend it? Is that interfering with the city's money under the Ripper Clause?
Respectfully, I don't see it from a perspective of interference. If you're taking the money and saying it has to be used for this purpose, for the construction of these homes, or you're taking the money and saying it's now going to be used for purposes of an inland port development, you're interfering with it in the same way. You're saying, okay, it's not money that the city gets to spend. And so I don't see a meaningful difference in terms of how the money is ultimately spent. If you view that as interference, then it's interference in both cases. But I don't think, again, number one, we're not a special commission, and so that wouldn't apply. But again, I think at the end of the day, in order to make sense of the case law, of this court's case law, tribe from Salt Lake County, and the Constitution, I just don't think it is there. There is a constitutional bar on the state in saying this money that's been raised this way can be redirected for another purpose.
It sounds to me like one of your arguments really is in effect, there's no such thing as municipal funds. Maybe that's an exaggeration of your argument, but that's how I'm hearing at least part of it. And so I want you to, this Ripper Clause certainly refers to municipal funds. So it's concerned with something. Is there such a thing as municipal funds in your view? And if so, what are the municipal funds that the Ripper Clause is referencing?
I honestly haven't thought through that prior to today. I would certainly think that there could be funds that are raised directly by a city that are raised in ways other than through assessment of property tax. But frankly, I'm simply not prepared to answer that. I really haven't thought through that. I'm just not prepared to answer that. I apologize.
No, fair enough.
Can I ask you another question along those lines? I have a similar question about the response to the argument about municipal functions. So it seems like, the city's arguing that zoning is a municipal function, and in requiring them to have zoning that permits an inland port, and then having the authority be in charge of decisions on the development of that area, that sort of delegating zoning to the authority. But I want to ask you about this idea of zoning as a municipal function. So the response is, well, the state gives that power to the city, and in giving it, we can take it back, right? Cities are a creation of the state. They don't have sovereign power. The state delegates its police power to the municipality. That's what lets them zone, and so we can take that back. But that would seem to be true of almost any municipal function. So I guess I have the same question that Justice Durant did about municipal monies. Couldn't you say about anything that the city says is a municipal function, well, the state gave you that power and we can take it back, so it's not really a municipal function, then what is the Ripper Clause talking about when it says municipal functions? What's left if we accept that argument?
Well, let me respond two ways. First, with respect to the zoning at issue here, the only zoning related provision that the state has actually challenged, it is simply a mandate that the city allow these uses. Just so you understand, the Port Authority has no discretion over that zoning. The Port Authority cannot go in and say, you need to allow this or you need to allow this. That's mandated. There has been nothing delegated to the Port Authority whatsoever. Simply has been no delegation. But with respect to the question, sort of more broadly, even assuming that it were, the municipal function analysis really comes back to City of West Jordan and UAMPS and this court's the case law talking about when we're talking about municipal functions, we're not looking at it in a vacuum, and we're not looking at it absent the context of the act and looking at what it is that the act is doing, what kind of power it gives, and what the purpose of the act is. And that obviously gets to this whole issue of statewide purpose and statewide function. And when we're talking about a municipal function, it's not any function that a municipality may ever have performed. The question is, in the context of the statute, are you giving this authority the power to exercise purely municipal functions? And here that's simply not happening. Understand that what the Utah Inland Port Authority does, what it's charged with doing, is looking at the fact that over $250 billion worth of goods pass through this state every year, from one end of the state to the other. And the authority's charge is to figure out how to maximize the opportunities that those goods moving through this state present, to mitigate the environmental impact of doing so. That's the Inland Port Authority's charge. This is clearly a statewide purpose, and the city's argument that it's not just doesn't pass muster. In that context, everything that the Port Authority is allowed to do has to further those purposes. And if you look at this court's Ripper Clause jurisprudence, City of West Jordan, UAMPS, there's never been a case where this court has said we have a definitive statewide purpose that's being pursued and struck it on Ripper Clause basis. And certainly here, given the nature of the opportunity that this presents statewide, this would present the clearest case of a statewide interest and statewide impact, certainly much more so than the urban blight that was that the state was trying to, or that was trying to be resolved in tribe. So that question of what is a municipal function cannot be divorced from this court's analysis of that issue. And at the end of the day, what the port does doesn't go in and say, well, we think a street lamp would look good on this corner, or this area should be residential instead of commercial. It's not what we do. Any project that we pursue, anything that we do, is always with the inland port purpose in mind. And in that context, this court has never held that those type of activities constitute purely municipal functions that implicate the Ripper Clause. Thank you.
Thank you, Mr. Strasberg. Ms. Lark.
Thank you. There are 2 points I'd really like to hit the rebuttal. I'd like to talk about this idea of the statewide purpose and this idea of an infusion with the inland, or the statewide purpose by it being an inland port. And second, the City of West Jordan decision doesn't help the state's argument with regard to mandates, and the tribe decision doesn't help the state's argument with regard to mandates or with regard to monies. Let's talk about the purpose. The court should not lose track of the fact of what this is at the end of the day. It's a private development. Let's transpose this to a hypothetical. If UPS or FedEx were going to come to town, would we be comfortable saying that the state could adopt legislation that drew a circle around a fifth of the city and said, you have to let FedEx operate anywhere in that 1/5. Got to allow it. You've got to allow them to transport these type of things. And as a statewide purpose, because FedEx operates in St. George, in Logan, and choose any other city you want. Therefore, we can pass this mandate mandating this zoning. I don't think anybody would be comfortable with that. So that's exactly what we have here. We have a private entity that wants to operate a private inland port. And we have state legislation mandating the zoning and the money that needs to go with that. And that rings absolutely true to what the RIPA clause was enacted to prevent. It was interference with local functions like zoning and monies at the behest of a special interest, private business. Let's talk a little bit about City of West Jordan and Tribe. The state says City of West Jordan.
Before you go on, Mark, with respect to redevelopment funds, where do those funds go?
Are we talking about
Just
property tax?
redevelopment agency funds, do they find a way into private coffers?
So if I might, I could do a quick 101 on how the redevelopment funds work.
Sure.
So, and this will actually go into why Tribe is completely inapplicable to any of the arguments, because a municipal redevelopment agency is set up, the decision is made by the city to make a municipal redevelopment agency. Once the municipal redevelopment agency is set up, I'm just going to call them RDAs because that's what we call them. They're governed by the legislator of the city. The city's council governs the municipal RDA, and then the city's council decides what money, its own money, is going to give to the RDA, and then the RDA generates and talks with private developers and develops the projects in line with how the city would want them.
So the RDA funds those private developers, right? I mean, through bonds and other mechanisms, that money goes to FedEx to build its facility.
Right, but the distinction here is the city chose to give its money to the RDA, and the city controlled the negotiation.
Fully understand that distinction. I'm just saying, if in this case, it may be the state that is electing to fund those private developers. And in your case, or the RDA, it's the city that's electing to fund those private developers, both through tax money. And in Tribe, it was an increase, as here, it was an increase in property tax value. I mean, to Justice Pierce's question, yeah, that's exactly what happened in Tribe, wasn't it? They set a benchmark based on the year prior to the RDA, and then any increase in revenue, property tax revenue up to a certain amount beyond that increase was being used to repay the bonds that the RDA was issuing. That's
correct. But the issue here is that there is the level of municipal consent at every single level. That it's the municipality that's spending the money. Here, like the money's been taken to someone else, operate in that model. Maybe the state could raise its monies in a different way, and then it could fund development in a different way. But the problem is this model works for RDAs because they're city created and city funded. It doesn't work here because you're using municipal money and giving it to somebody else.
Ms. Slark, could you just quickly address on this argument about zoning being a municipal function? How is this a delegation? I think that the authority and the state have a pretty good argument that, look, the zoning is a direct mandate. It's a one-shot thing. We're telling you you have to allow inland port development and to zone it for that. And then the authority is not involved in zoning anymore. So how is that a delegation of zoning authority if we assume zoning authority is a municipal function?
So we're not arguing that it's a delegation. We're arguing that it's a mandate, and we're arguing that we cannot adopt a rule that direct mandates avoid the RIPA clause. Because if we make that ruling, then you can just avoid the prescriptions of the RIPA clause by just passing a direct mandate. Remember that the RIPA clause is to preclude interference with local control at the behest of a special interest. This court has set a long history of being willing to find that mandates are subject to a RIPA clause analysis. It started with the general idea back in Wright. Then in Bachman, there was a clear analysis of a direct mandate. And that actually brings me to the point of what I'd like to discuss about City of West Jordan. which I don't think that it helps the state's argument at all in that case. Because what was the statute there? The statute there was municipalities, if you are going to provide retirement for your employees, you have to provide retirement in this way. And this way is you need to provide it through this state-funded retirement system. And the court said, okay, they didn't just say, we're not going to analyze this under a Ripple clause analysis at all. They went to the second point and did decide whether it was a state function or not. But I think that the point with regard to the mandate is, they said, oh, it's not a mandate because you have the choice of whether you're going to provide retirement to your employees or not. And if you provide them in this way. But if you don't, then you don't. Let's apply this to this circumstance. Say, I guess we had a mandate, it was like, you're going to allow this, you have to do it in this way. But the point is that there's been no clear rule ever in the precedent of this court that direct mandates escape analysis under the Ripple clause. And I think that's for very good reason, because if you found that the state could just legislate directly, then you've just eviscerated the protections of the Ripple clause. Take any private development that wants you to go somewhere completely inappropriate within a municipality. Say a coal mine, I don't know, I'm just going to make a ridiculous example. Say a coal mine wanted to go into a residential neighborhood. The city says no. Coal mine goes to the legislator. The legislator passes a statute, draws a circle around the avenues and says, got to allow a coal mine in here because it's for a statewide purpose. It's going to be an economic generator for the entire state. Therefore, we can override your local zoning for this statewide purpose. That's no different from what's happening here. A circle got drawn around a fifth of the city, and we were required to have zoning that will allow an inland port uses anywhere in this 1/5 of this area and the transportation of natural resources. And that is interference with local control at the behest of a special interest. And if the court doesn't have any other questions.
Thank you, Ms. Lark. Mr. Purser, Mr. Strasberg, we very much appreciate the briefing and the argument in this case. It's a very important case, quite obviously. And we will take it under advisement. At this time, court will be adjourned. Thank you.
Thank you.